Today we'll continue our series on citizenship. Citizenship. How did you get here? I'm not able to. We are continuing our series on citizenship, and today we are continuing with the automatic. Not getting this thing. Can you please help me? So, if you have questions, send in your questions. Today we are discussing automatic citizenship for children of naturalized citizens. Children of naturalized citizens. We'll get questions all the time about this topic. When people apply for citizenship and they become US citizens, they want to know what the status of their children, what the status is, whether those children automatically acquire citizenship or whether they also need to apply for citizenship individually. So we get those questions all the time, and that is why we are discussing that in this series of citizenship topics. So today, if you have questions relating to the status of your children, if you are a naturalized citizen and you want to know the legal status of your children, you can send in your question. That is the topic we are discussing today. Let me give you an overview. Usually, when a permanent resident, legal permanent resident, apply for citizenship and then attend the interview, the application is approved, the applicant is sworn in as a citizen. On that day that the applicant is sworn in as a citizen, every biological or adopted child who are already permanent resident but who are under the age of 18, they all become automatic US citizens on that day. So, if you are a naturalized citizen, if you naturalized today, any biological child who is under 18 years old, they automatically become a US citizen. So, they do not need to file application for citizenship separately. They can only do one of two things. They can go ahead and apply for American passport. Alternatively, they can apply for certificate of citizenship, something that will show that they are automatic citizen. But personally, I just advise clients to go ahead and apply for American passport. Passport itself will show that the children are US citizens. So in applying for passport, they will need to go with the original green card, the original of the father's certificate of citizenship, and of course, they need to complete the application and pay the fee for naturalization. So usually, I advise clients to apply for passport together at the same time. So as soon as the naturalized citizen is applying for passport, then the children too should be applying for American passport because they acquired automatic citizenship as soon as the father was sworn in. However, for children who are already 18 years old or above, they are not automatic citizens. If the children are already 18 years on the day the parent naturalized, they are not US citizens. So in such a situation, each of the children will have to apply for citizenship individually. They will have to apply for citizenship individually. Now, what about children outside the country? The same thing applies. Every child, biological or adopted, who are outside the country at the time of naturalization, they are not U.S. citizens. They are not automatic U.S. citizens. They are not even permanent resident. They remain a foreigner. However, when the parent become a naturalized citizen, they can file a petition on behalf of those children abroad. If those children, at the time of entry into the United States as a permanent resident, if they are under 18, they will get citizenship instead of green card. But if they are 18 and above, they will get only a green card, and then we'll have to wait to be eligible for citizenship and apply individually. So keep questions coming in, keep questions coming in, keep questions coming in. Today, we are discussing automatic citizenship for children of naturalized citizens. Automatic citizenship for children of naturalized citizens. So, for the purpose of those who are joining us late, what we have been discussing is that when an applicant naturalized as a citizen of the United States, on the day the applicant become a U.S. citizen, on that day, any biological or adopted child that is physically present in the United States in permanent resident status with a green card, if they are under 18 on the day that the parents become a U.S. citizen, at least one of the parents become a U.S. citizen, those children acquire citizenship automatically. They do not need to apply for citizenship. They do not need to do anything. They automatically become a U.S. citizen for as long as they are under 18 years old on the day that they are at least one of their parents become a U.S. citizen. On the other hand, if any of the children, if they are already 18 and above, then they will have to apply for citizenship on their own individually. The parents' citizenship will not impact them. The citizenship of naturalized citizen will only apply to children of naturalized citizens who are physically present in the U.S. in a permanent resident status. In other words, let's say someone won a visa lottery, came to the U.S. with his family, his or her family, let's say a family of 4, father, mother, and 2 children. Maybe the 2 children are 10 and 8 years old. Then after waiting 5 years, one of them or both of them become a U.S. citizen. If on that day that they become a U.S. citizen, one of the parents become a U.S. citizen, maybe one of the children is 18 and the other is 16. The one that is 16 automatically become a U.S. citizen. He or she does not need to do anything other than just to apply for American passport. The one that is 18, on the other hand, will need to apply for citizenship on his own merit. He will have to meet the requirement of citizenship. He will have to go for interview. He will have to pass the test of civics. He will have to demonstrate that he can speak English, he can write English, and he can read English. He will have to show that he is of good moral character. So he will have to meet all of that. But where the children or the child is under 18, citizenship is automatic. The reason we are discussing this topic, one of the major reasons, I've seen situations where, especially teenagers, where children in some cases get involved in some criminal activities, maybe got involved with bad gang, and then got sentenced, developed criminal record and all of that. If the child is automatic citizen, all this will not matter. Even if the child is convicted of aggravated felony, it will not matter for as long as they are automatic citizen. On the other hand, If the child is not automatic citizen and then the child had some convictions, that may be a problem. Not only can it impact citizenship, it could actually lead to deportation. So it is very important to know all these basic rules, to know all these little things so that we avoid mistakes, we avoid error, not impact the children outside the United States. This automatic citizenship issue is only applicable to children who are physically present in the US in a permanent resident status. So if the children are outside the United States, the parent will still have to go through the process of filing a petition for the child and go through the embassy and go through immigrant visa process. If that child, however, entered the United States before age 18, the child will not receive a green card. The child will receive citizenship, automatic citizenship. So that is the way automatic citizenship works for children of naturalized citizens. So I see that questions have started coming in. So before I go on, let me start answering the questions. The first question here, you said that this applies to children and adopted children. Does this include minor stepchildren? My spouse child is a green card holder in the US, and I'm about to get my own citizenship. Well, if your stepchild is a green card holder, how did he get the green card? Is it based on the petition that you filed for the spouse? If it is based on the petition that you filed for the spouse, if the marriage that created the stepchild relationship was entered into before the child turned 18, and at the time of the approval, the child is also still 18. But there's one thing that you need to understand here. A stepchild relationship is not the same thing as adopted relationship. You may marry someone and not adopt the children. So you have to create a stepchild relationship is something that is created. So in this case, if the stepchild relationship is created, in order to create it, one, the marriage that created the stepchild relationship must have existed before this child turned 18. Secondly, there must be parental relationship between the stepchild and the step-parent. So it is not by mouth that, oh, this person is my stepchild. No, there must be parental relationship. For example, the child must be living with you. You must have, school records, medical record, pictures. Maybe you list the child on your tax return. You take joint or family trips together. You must create a stepchild relationship. It is not verbal. You don't just have a stepchild relationship just by marrying the mother or the father. So there must be evidence of stepchild relationship. So if you meet this condition and you become a naturalized citizen before the child turns 18, then that child will also acquire automatic citizenship. I hope that is very clear. If not, you can send a follow-up question so that I can clarify it further, but I believe it should be very clear. The next question. I did not know about this. I was naturalized in 2017 and my child was 14 and had a green card. Does this mean my child is a citizen? How do I prove it? This is very simple. The answer is yes. It doesn't matter how long after. To do is one, go and apply for American passport for your child. Or if you don't want to do that, you can apply for certificate of citizenship for your child. So when you do, these are the things you are going to attach. Either you are applying for passport or you are applying for certificate of citizenship. You provide your own naturalization certificate. You provide your child's green card. You provide evidence of relationship, evidence that this child was living in your custody in the US at the time, at least up to age 18, prior to age 18. So if you have all this evidence, your child is automatic citizenship, is a citizen. It doesn't matter how long ago. It doesn't matter whether you have taken steps before now or not. It doesn't matter whether because you didn't know then. No, it's still a citizen is a citizen. It doesn't matter when you claim or when you apply for evidence. The only thing you are applying for is evidence of citizenship. You are not applying for citizenship because based on this fact, your child is already a US citizen. When you became a naturalized citizen in 2017, your child automatically became a US citizen. So the only thing you need now is evidence of citizenship. And this evidence of citizenship, you can get it one of two ways. One, you can go directly to the Department of State and apply for American passport for your child. Complete the application. If you are going to apply for passport, you will need to submit original certificate of naturalization. It cannot be a copy. If you want to apply for certificate of citizenship for your child, then you can submit a copy. But if you are applying for a passport, you will have to submit the original certificate of naturalization. You will also need to submit the original green card for your child. All these original documents will be returned to you when the passport is issued. But before the passport is issued, you will have to submit the original green card, you have to submit the original certificate of naturalization, and then you have to submit evidence. Those ones can be copies. Evidence that this child was actually living in your physical custody at the time. This evidence could be tax return, school record, evidence of joint trip, family pictures, medical records, everything that shows that this person was living in your custody. So once you submit it, they will issue a passport and then they will also return all the original documents that you provided. The next question. Does my child need to apply for a naturalization certificate before applying for a US passport? No, I already answered that. No, your child does not need to apply for naturalization certificate. Based on this fact, all you need to do, just go to passport office with your child physically. So go with original certificate of naturalization for yourself, not for your child, for yourself. Original green card for your child. Of course, your child who is applying for American passport will need to go with 2 passport photographs, 2-inch by 2-inch white background. Then copies of evidence of relationship. If you have tax return, where you listed this child as your child, make copies. School record, make copy. Medical record, pictures, family pictures, evidence of joint trips, things that shows that this person was living in your house. If you have a list that listed the occupant and your child's name shows up, attach all these things. All this must be before the child turns 18. So if you are providing current evidence after 18 years, it will not work. It is evidence before the child turns 18. That is all that you need. And you can apply for green card and for citizenship or for American passport directly. You don't need to apply for any naturalization certificate. In fact, automatic citizen does not require naturalization certificate because from the name, it is only when you naturalize that you get naturalization certificate. So when a child acquires citizenship, you don't need naturalization certificate. But if, apart from the American passport, if you still want a certificate to show that your child is a citizen, then you can apply for certificate of citizenship. That is different from naturalization certificate. It is certificate of citizenship. It is called N600. You apply using form N600, but usually you don't need it. Once you have an American passport, you don't need it, because it is that initial passport that you need to submit your own naturalization certificate and all of that. Once the initial passport is issued, going forward, when it is time to renew, your child is no longer going to need your certificate or anything like that. So you really don't need a certificate of citizenship. But if you want it for your record, you can always apply using form N600. So in this situation, your child remains automatic citizen. The next question. My citizenship was approved at my N400 interview. My child, 12 years old, received a green card 2 days later. However, when I went to my oath ceremony, she had the green card. Is she a citizen? Yes, she's a citizen, because it is the date of naturalization. It is the date that you are sworn in. It is that day that you become a U.S. citizen. You don't become a U.S. citizen on the day you pass the interview, because you can pass an interview and still be denied citizenship. You can pass I've actually seen this before. You can pass an interview, you can be recommended for citizenship, you can even be given a swearing-in date. You become a citizen. So it is the day of swearing in that you become a U.S. citizen. That is the date that will be on your certificate of naturalization. So if your child was already a green card holder before that day, then, and the child is under 18, that child becomes automatic U.S. citizen. The next question. Okay, this is a two-part question. Part one. I filed for my 2 daughters through consular processing as a permanent resident. While the cases were pending, I became a U.S. citizen. I notified the National Visa Center about this. Okay, part 2. And they expedited the process for my daughter, who is under 17, but not for the one that is 19. Why couldn't they be processed together? Well, the issue of processing, that has to do with the National Visa Center. That's not an explanation I can give. It's the National Visa Center or the embassy that can explain that. But the issue here is that if your 17-year-old, if that child entered the US before 18 years old, that child automatically become a U.S. citizen. In fact, immigration will not issue green card, because that child becomes automatic citizen. So as soon as the child entered the U.S., they will send him or her a letter confirming his or her citizenship. But the one who is already 19, that one will not become automatic citizen, but will still be your immediate family. For as long as he gets into the US before age 21, he will still fall into your immediate family category. But on his own, he will have to meet the requirement of citizenship and then apply for citizenship separately. But honestly, I cannot understand why the embassy or National Visa Center will separate this, because both ages 17 and 19, they still fall under immediate family category. Okay. Okay, I got additional information that they sent an email that they wanted to process it faster, so as maybe they realized that the automatic citizenship thing, they didn't want to deprive her of that opportunity, of that benefit, which is a good thing, because the one who is already 19 has already lost the privilege of becoming automatic citizen. The requirements are different, so because they realize that if that child gets to the US before age 18, the child becomes automatic citizen. So that's actually a help from the embassy. The next question. I was naturalized before my child received his green card. He is now 15. Can he apply for citizenship now? No, he cannot. He has to be 18 in order to apply for citizenship himself. And two, he has to be a permanent resident for 5 years in order to be eligible. So since you already got your naturalization before the green card was approved, automatic citizenship is already off the table. So your child will have to be patient and then go through the process. But at least he can continue to enjoy his green card. So keep the questions coming. Do I have questions there? Okay. Yeah, keep the questions coming. Today we are discussing automatic citizenship for children of naturalized citizens. Automatic citizenship for children of naturalized citizens. So wherever you may be, you can send in your question. This is an opportunity to get your questions answered. And as we can see from some of the questions we have answered today, it is clear that there are people out there who do not know all these little things, and it makes a big difference, especially for those who have teenagers as children. I mean, we all know what teenagers do. Most teenagers get into trouble. Most teenagers, that is the age that they do all kinds of things. So if your children are automatic citizenship, take advantage of it so that even if anything happens, they don't face deportation or face any risk with their immigration status. Once you are a citizen, you are a citizen. There is no amount of crime that could be committed that can take your citizenship away. Even if a US citizen commits murder, you cannot be deported. You are still a citizen. The only time that a US citizen can be deported is if immigration can prove that the citizenship was obtained by fraud. So there is a legal maxim that says you cannot build something on nothing. So if the citizenship itself was obtained by fraud, then it can be taken away. Other than that, if no fraud was involved at the time of citizenship, there is no amount of crime that a US citizen can commit that can take away the citizenship or lead to deportation. So you might want to go back and look at your paperwork. Go back and look at your own citizenship. When did you become a citizen? At the time you became a citizen, what are the ages of your children? Are your children automatic citizens? Did you take advantage of this? Did you know? If yes, why not? Have they already applied for passport? Are they already aware that they are a citizen? So if not, just take the step right now. Take the step right now before it is too late. Now, the next question. I am now eligible for naturalization. My wife is petitioning for my child through consular processing. Should I wait until my child gets his green card before I apply for naturalization? No, before age 18, that child becomes automatic citizen. So in fact, it is in your interest to go ahead and naturalize while you are waiting for the processing for your child's application. Because for as long as that child gets here into the US before age 18, that child comes in as a US citizen, not as a green card holder. He or she will come in as a US citizen. So go ahead and apply for your naturalization. It will only benefit your child. It will not have any negative impact on your child's application. Keep the questions coming in. Keep the questions coming in. Keep the questions coming in. Today, We are discussing automatic citizenship for US for naturalized citizen. Automatic citizenship for children of naturalized citizen. This topic is very important because every topic we discuss on this podcast, it is either based on experience or based on popular demand. And this particular topic is based on what we have seen based on experience. I have seen people who became a naturalized citizen, but for some reason, they didn't realize that their children are already a citizen. And then along the line, those children in high school, they got into some trouble and then they were placed in removal proceedings because there was no evidence that they are US citizens. Immigration cannot deport a US citizen. But when there is no evidence that they are citizens, anybody can be deported if there is no evidence that such a person is a citizen. So it is not immigration's responsibility to do your job for you. Immigration is not the one that will tell you that, oh, Mr. Asekun, you are already a citizen, come and apply. No, that is not immigration's job. It is your job. So if you have the opportunity, you are the one that should take advantage of the opportunity. So if you don't know, you don't know. And what you don't know sometimes can create problem. That is why we are giving out all this information and letting you know. I have seen a situation where a US citizen was placed in removal proceedings. I have seen a situation where a US citizen who didn't realize that he was a citizen went to Canada illegally and then re-entered the US and then was placed in removal proceedings, and the case is still dragging on even until today, despite the fact that this person is a US citizen, but they didn't know, they didn't have the proof. And unfortunately, delay sometimes can be denial, because when a child acquires automatic citizenship, if you don't apply for American passport or evidence of citizenship in the form of certificate of citizenship, if you delay for too long, by the time you need to apply, you will still need to provide documentary evidence that that child was actually living with you while under age 18. And you and I know that a lot of people, sometimes they are careless with documents. Some people, if you ask them for document that they had 5 years ago, they can't find it. Some people tell them to go and bring the list of 2015. They can't find it. So it is better to apply at a time that you will easily be able to provide this document than to wait till a time that, even though this child is a citizen, but proving it will become problematic, because the law is the law and nobody is above the law in the United States. So if you don't, the law requires that you show evidence that this child was physically living with you in the US at the time you became a naturalized citizen. So if you do not have the evidence, if you are renting a house at the time, you will need to provide the lease. If you do not have all these documents, if you delay for too long and you end up not having this document, it may be problematic. So that is why we are giving you this information right now. If you are eligible, go ahead and apply and do not wait. Let your children enjoy the automatic citizenship. The next question. Once the parent is naturalized, does the minor child, green card holder, need to pass a citizenship test? No. The child does not need to do anything. The child does not need to do anything. No application to complete, nothing. The only thing you need to do is just go ahead and apply for American passport. And if you are going to apply for certificate of citizenship, the child does not get involved. The child does not need to do anything. You just submit evidence of your own naturalization, which is a copy of your certificate of citizenship. After that, you have to submit evidence that this child was living in your physical custody before the child turned 18 years old. That is all you need to do. So the child is not going to go through any civic test. The child is not going to submit any application for naturalization. The child is not going to have to show that he meets the requirement of citizenship. No, because the citizenship in this case is automatic. So the child does not need to do anything at all, other than to apply for passport or to apply for certificate of citizenship. The next question. My child's US passport expired. He was asking to prove US citizenship. They are not accepting the expired passport. Should I get a certificate of citizenship in order to avoid this issue in the future? Well, it is very, very rare. I mean, it is very rare for them not to accept a prior passport, except if at the time of renewal that child is still under 18. If the child is still under 18, they will still need parental consent, and of course they will need to show the parental citizenship as well. However, to my knowledge, I mean, and I've done this several times, even including for my own biological daughter, I've applied for renewal of American passport using only the expired passport. So there must be a reason why they are asking for this thing. But again, all you need to do is just to show evidence that that child was living with you. If you have been filing your tax return claiming the child, show copy of the tax return, show copy of your lease or mortgage, show the child's school record, show the child's medical record. If you have family pictures that you take together, show it. If you are the type that takes vacation all the time, show evidence of vacation pictures, vacation travel plans, ticket, boarding passes. All these things will be evidence that this child was living with you. But if you want to apply for certificate of naturalization, that is not a problem. You can apply for N600, and you apply for N600 and you pay the fee. But with N600, you still have to attach evidence of your own citizenship. You have to attach evidence that this child was physically living with you at the time of your naturalization. So all the things that I listed, you still have to apply to attach in order to get the certificate of citizenship. That is, your lease, if you are renting at the time and your child's name is listed as one of the occupants, you send in your lease. If you have been filing your taxes and claiming the child as your dependent, you submit your tax return. If you have a school record, of course, if a child lives in this country, definitely the school record will include the parent's name, medical record, all these things, pictures, family pictures, travel pictures, all these things you attach. The next question. What if I don't have sole legal custody, but there is a problem with the other parent and I can't get a signature for the passport? Well, I know that there is a form. That the passport office will give you to sign if you cannot get the other parent to sign. However, I also do know that the government is reluctant to give passport, American passport, to children whose the other parent is not part of the application process. Usually, they will tell you to get the other parent to sign an affidavit, to sign a release authorizing them to issue passport. But where you can demonstrate that maybe from inception, maybe since the child was born, the father or the other parent have not been involved in the child's life and all of that, you can show all of this evidence. But the easiest way is to have what is called legal custody document. That is the easiest way if the other parent is not involved. All you need to do, get a divorce lawyer, file what we call SAPSA, suit affecting parent-child relationship. So let the court make an order that you are the sole custodian of this child. So whenever you want to apply for passport or do anything on behalf of the child, you just present this order and nobody will ask any additional question. The next question. I'm about to apply for N400. I am a man and I have a daughter that has a green card. The problem is the mother claimed another man as her father for her green card. What can I do to help her? Well, this is a complicated one. It will be tough for you to help her because, number one, since she has a green card and in the application process, another man was listed as the biological father. So whatever you file right now, immigration will not believe that you are the father. So the same way, if you apply for passport for her, they will not approve it, because if you submit your own certificate of naturalization together with the application for passport, since the Department of State is going to verify her green card, they will see that another person was listed as the father. So this is a complicated process. What I will do, depending on the age of the child, if this child is close to 18, you don't need to do anything to try to help her. Let the child go ahead and apply for citizenship on her own when she turns 18. Let her apply for citizenship on her own. However, if this child is still small, let's say the child is like 10-year-old, yes, what you will need to do is to first go to court to go and challenge the fact that you are the father. You go and challenge the paternity. Go to court so that the court can order DNA and you can establish paternity of this child. Once the paternity is established, then you can file a motion with immigration asking them to update the child's record to reflect that you are the biological father, that you have established that you are the biological father. So after all of that is done, then you can think of a way to help the child become a automatic citizen. But like I said, it's a complicated process. So my advice to you, if this child is close to 18, let the child wait and apply for citizenship on her own. That doesn't mean you cannot fight paternity. You can still fight paternity, but let our immigration process not be complicated. You can still go ahead and go to court and challenge the paternity. So, and if you do, before the child turns 18, the child can apply for citizenship and then update our own record, stating that, well, I now find out that my father's name is this. The truth of the matter is, even if this child is young, if you succeed in proving that you are the biological father, if you succeed in establishing paternity, you will still face another challenge. This child will still not be able to claim automatic citizenship because you have to show that you are living with this child and based on this fact, I'm assuming that this child was probably living with the other man. In order for the other man to file green card for her, she was probably... So you are going to face the challenge of establishing a parent-child relationship. So you may not have the child listed in your tax return. You may not have the child listed you may not have your name listed in the child's school record. You may not have your name listed in the child's medical record. A lot of things that you will need to establish paternity, you may not even have it. So, like I said, my suggestion, and based on the fact that you presented here, if I was in your shoes, I would just wait and let the child turn 18, let her apply for citizenship on her own. If you succeed in establishing paternity before she turns 18, she can actually request immigration to update her record when she applies for citizenship. And in that case, you don't need to prove that she was living with you. So whether she lived with you or not, all that will be immaterial. The material thing will be that the correct father is this, and she will show all the court order confirming that you are the biological father. So that is what I will advise in this case. The next question. My child was admitted as a legal permanent resident and is eligible for U.S. citizenship but has not been issued a social security because my A number and his are the same because of an error from USCIS. Can my child still apply? No, I'm not sure I understand this question. My child was admitted as an LPR and is eligible for U.S. citizenship. So this is not talking about automatic citizenship. Okay. Well, today we are discussing automatic citizenship, but I will still go ahead and answer this question. My child was admitted as an LPR and is eligible for U.S. citizenship, but has not been issued a social security number because my A number and his are the same because of an error from U.S. Embassy. Can my child still apply? Oh, yes. In fact, it will be an opportunity to fix the problem. It will be you know that sometimes when immigration makes mistakes, when there are errors, and you are communicating with them either over the phone, through the email, or you are writing letters to them, it's not the same as when you are talking to a live person. So if your child apply for citizenship, especially in Dallas right now, citizenship in DFW right now is being processed very fast. I mean, we have seen cases of people who are called for interview in less than 3 months. We have seen 3 months. We have seen 4 months. So it's getting processed very fast right now. Yes, let this child go ahead and apply for citizenship. Once the child applies for citizenship, when the child gets to the interview, he can now bring up all these issues. The mix-up, the lack of social security, the A number mix-up and all, and that thing can be corrected right there on the spot. I mean, corrections are easier, are much easier to fix when you are talking to a live person, especially an officer who will have your file in front of him or her. Because usually when you are invited for interview, the officer will have been sent your file in order to be able to conduct the citizenship interview. So the officer will have your file in front of him or in front of her. So that is the easiest way to get the problem fixed. So let your child go ahead and apply for citizenship. That is the best time. That is the best time. I think I have another question. Just a minute. Okay. The next question. Okay, this is a follow-up from the... Okay, follow-up on what? Okay. About my daughter and her green card. Is it possible she could lose her green card if I try and prove she is my daughter? I do not want to do anything that could get in our trouble. Oh, okay. I assume that this is the question about another man being listed as a father. Okay. Well, as I stated earlier, if you follow my advice, you will not have any challenge. My advice is that leave this child, let the child turn 18, let the child apply for citizenship on her own. Once the child apply for citizenship on her own, then you can establish your paternity. But even you can even establish your paternity before then. What you just don't do is to attempt to file any petition or attempt to make the child become automatic citizen through you. That is what will complicate things. Let the child, you go ahead and establish paternity. If this child is your biological child, go ahead and file a suit in court and challenge the paternity. Let the court order DNA. Do all these things, but do not attempt to file any petition or do not attempt to do anything legally for this child. But you just establish your paternity. When the child turns 18 and now apply for citizenship on her own, she can now show that you are not, that the person listed on her green card as the biological father is actually not the father, and that the real father is you. She can now tender the document. This will not affect her in any way because that would not be a fraud. If she didn't know, whoever she believes or whoever the mother told her is the father is what she listed. So if it turns out that you are now the father, that will not be counted negatively towards her. But if you attempt to file something for her, that is when there could be trouble. So you can, but if you want to play safe, wait for her to become a citizen before you even go into all this paternity battle. The next question, oh, okay, for clarification, she is young, only 8. Oh, if it is only 8, well, however, one thing that this question did not state is the status of the biological mother. So is the biological mother also a U.S. citizen, or is the biological mother a permanent resident? Because we don't know. I mean, I'm guessing right now because this question did not state the position of the biological mother. If the biological mother is in the picture, if she is a permanent resident, just so, and I'm assuming the mother is in the picture, so let the mother handle it. So let the child become a citizen through the mother. That doesn't stop you from establishing paternity, because if the child is still 6, you still have a long way to go. I mean, 18 is still far away. That's still like 12 years ahead. So let the mother just handle it. You go ahead and face the paternity issue. So I'm assuming that the mother in the picture. So, oh, okay. Clarification. She is not a citizen. The mother is actually in removal proceedings. If the mother is not a citizen, how come the other father was able to petition for this child? I'm okay. This is a little confusing. Well, one thing I want to be sure of, and this is why I'm a little reluctant here. I want to be sure that I'm not confusing you. I want to be sure that I'm not giving you bad advice. This case seems to be a little complicated. I will suggest that whoever sent in this question should contact our office and schedule a one-on-one appointment so that there is no misleading issues here. Because I'm only going to advise based on the information that I have. I cannot advise based on the information that I don't have. And right now, I don't seem to have the total picture. I don't seem to have the total picture. And without having the total picture, there is tendency that I may misadvise you. There are things that I don't want to discuss live during this program concerning this topic. I don't know if this is immigration related, if this is a normal family tussle. To me, it seems there are more to this question. So my advice at this stage, based on the information I have so far, I would suggest that you contact our office, schedule a one-on-one appointment so that, one, you will be able to enjoy privacy, you will be able to have attorney-client privilege, and a lot of questions that I could have asked right now, I don't want to ask during a live program because I don't want to wash your dirty linen in public. So I'm just going to advise whoever is sending this question, contact us, schedule a one-on-one appointment so that I'll be able to get the total picture. So that, because I've always told people that half information is more dangerous than no information at all. When you don't have information, the tendency is that you will not step out of your boundary. You will not take wrong step. You will not even take any step out of fear where I don't have the total picture. What we are doing on this program is general question. Suggest that you schedule an appointment. You don't necessarily have to see me. I mean, you can contact another lawyer, but all I'm just saying is that this is not a live program conversation. That is all I'm saying here. So keep the questions coming in. Okay. Yeah, okay. This seems to be the last question. So in the absence of any additional questions, we'll be ending today's program. Remember to join us again next week. Remember to invite your family, friends, colleagues at work. Remember, this is every Wednesday, 12 p.m. Central Standard Time. The only thing you can do to show appreciation for what we are doing we are doing for free of charge. We are not charging anybody for this. And we are not afraid to answer any question, no matter how complex, except where open discussion can be problematic, like the last question I dealt with. So other than that, we are doing everything free of charge. So the only way to show appreciation for what we are doing is to let other people benefit from this information. The Bible says, my people perish for lack of knowledge. And also, we also know that the difference between people who are succeeding in this country and people who are struggling, the difference is basically information. You see some people, they take one wrong turn and that can set them back for 20 years. You see some people, they take one wrong turn. They may not even survive it. It may end up in deportation. Whereas you see some people, they are making the right turn. Things are going on. The basic difference is information and mercy. But you still have to play your part. That is why we are trying to play our part to encourage people to provide the missing information based on experience. We have seen, as I've stated in this program, I've seen people whose children, as teenagers, these didn't even know that they are U.S. citizens. I have a few of those cases that I'm still defending right now in court of people who are citizens. In fact, I have a case that I am currently at the Board of Immigration Appeal level, BIA level, over it, and I'm convinced that this person is a U.S. citizen. I have another case that I've been fighting for more than 10 years now. I have presented evidence to the court that this person is a U.S. citizen. The court decided that they don't want to go into whether the child is a citizen or not. If I believe that the child is a citizen, I should go ahead and prove that with USCIS. We have applied for certificate of citizenship, but guess what? Because of long delay, the parents are no longer able to obtain all these documents that are required. As I stated, how many people can produce a lease that they signed that they signed 10 years ago? How many people can still lay claim to lay hand on such a lease? How many people can get tax return they filed 10 years ago? How many people can get copies of a trip that they made 10 years ago? So some of these things, delay can be dangerous. So if you are eligible, take advantage now. Go back and look at your green card. Go back and look at the date you became a citizen. Go back, if you have children who are physically present in the US, go back and look at the date, their age when you became a citizen. If these children are under 18 at the time you became a naturalized citizen, these children are automatic citizens. But you can't prove automatic citizenship by mouth. There are documentary evidence required. In order to prove it, there are two things you can do. You can either apply for American passport or apply for certificate of citizenship. If you are going to apply for American passport, you will need copy of your own naturalization certificate. You will need the original green card of your child. You will need evidence of a parent-child relationship, evidence that this child was living in your physical custody at the time you became naturalized citizen. That means that at that time, you have to show that the child was living with you. If you are renting a house at the time, you will need the lease that will list the child as one of the occupants. If you file tax return at the time, you will need copy of the tax return showing that you claim this child as a dependent on your tax return. If you've taken trip, you will need copies of all your trip ticket and all of that. You will need school record showing that this child, you as a parent, was listed on the child's school record. If you will need, then if you are applying for certificate of citizenship, you need exactly the same thing. The only difference between applying for passport and applying for certificate of citizenship is that in the case of application for citizenship, you can show copies of all these documents. In the case of applying for passport, your certificate of naturalization has to be original one, and the child's green card has to be original. Both of them will be returned to you upon the approval upon the issuance of the passport, but you need the original one. So we'll be hanging up today. We hope to see you next week. Remember to invite your family and your friend. See you next week. Thank you for joining us.